We are counting down the 5 legal traps that land on sailboat owners when the market stops moving and the hull keeps sitting in the water. From unpaid slip fee liens to state impoundment orders, each entry on this list is documented in existing law, actively enforced by state agencies, and already buried in the fine print of whatever paperwork changed hands the day you took ownership. Ranked from expensive to catastrophic, some of these traps carry a $15,000 disposal bill. Others track the last registered owner through a private sale that happened years ago and across state lines. Which trap now carries a criminal felony charge under legislation signed in 2025? That is trap number 1. The boat owners who get hit by these traps did not stop caring about their vessels. They stopped being able to sell them. Between 2020 and 2021, over 1 million used recreational vessels changed hands in the United States, and manufacturers sold another 320,000 new boats into the market. The pandemic drove a buying wave the industry had not seen in a generation. That wave is gone. The boats remain. In a market where listings sit for 18 months and buyers have disappeared from entire regional coastlines, the Pacific Northwest, the Great Lakes Corridor, the Southern California harbors, the vessel that was a liquid asset in 2021 has become a liability with a 12-digit identification number stamped into the stern. The state has that number on file. It has had it since the day the title transferred. Before the countdown begins, the numbers that make these traps a current problem, not a theoretical one, need to be on record. The Florida Fish and Wildlife Conservation Commission logged 1,040 active derelict vessel cases in the state as of January 7, 2023. Each one is a hull with an identifiable registered owner sitting on state waters, accumulating removal costs. Florida's annual expenditure on derelict vessel removal climbed from nearly $2 million in 2020 to nearly $13 million in 2024, a figure that almost doubled in a single year. The Commission puts the standard removal rate at $400 to $800 per foot of hull. A 30-foot sailboat, under ordinary conditions, costs between $12,000 and $24,000 to remove. The Maryland Department of Natural Resources documents fiberglass sailboat disposal at $3,000 on the low end and $15,000 for a larger hull. California marina operators surveyed by Practical Sailor magazine report the full cost of legal processing, removal, and disposal at $20,000 to $40,000 per derelict boat. If the vessel sinks at the dock before removal, that figure doubles. On average, 600 new derelict vessels are added to Florida's enforcement database every year in non-hurricane years. A single major storm can add hundreds more overnight. These numbers are not projections from a trade association. They are line items from state budget documents and active enforcement programs that are already growing. The 5 traps below explain exactly how a registered boat owner ends up inside those figures. Trap number 5, the graveyard slip. A marina berth is not a parking space. Under the Federal Maritime Lien Act, when a marina provides services to a vessel, such as dock space, shore power, pump-out access, a maritime lien attaches to the hull automatically. No paperwork is filed. The lien requires no recording anywhere. It exists by operation of admiralty law the moment the service is rendered, and the vessel owner receives no notice until the lien is enforced in federal court. The lien stays attached to the vessel through every subsequent sale unless it is discharged through a federal court-ordered marshal's sale. This is not a minor legal technicality confined to commercial shipping. A slip at a corporate-managed marina on the Atlantic seaboard now runs $800 to $1,200 a month at the entry level. 3 years of unpaid fees, the kind that accumulate when an owner stops responding to monthly statements, amounts to between $29,000 and $43,000 in lien exposure attached to the hull itself. A buyer who purchases that vessel through a standard brokerage transaction with a clear title check through the state DMV system, receives the lien alongside the keys. DMV title searches do not disclose maritime liens. They are invisible to the standard chain of title review a broker runs. A maritime attorney writing in the log confirmed the mechanism directly. The vessel itself is the liable party under Admiralty law, and the lien follows the hull through multiple changes of ownership. Officers at state vessel enforcement agencies know the pattern. Boats moved quietly from marina to marina, each new slip adding another layer of undisclosed wharfage to the vessel's legal profile. That is one trap closed. The fix requires one specific action. Before closing any vessel purchase, obtain a written lien clearance statement from every marina where the boat has been berthed in the past 3 years. A signed bill of sale does not substitute for that letter. Trap number 4, the charitable donation. The pitch is familiar. Donate the boat to a registered non-profit organization, receive a fair market value tax deduction, and hand the disposal problem to the charity. The IRS does not handle this the way the donation industry describes it. Under IRS publication 4303, when a donated boat is later sold by the receiving charity, the donor's tax deduction is capped at the gross proceeds the charity actually receives at auction, not the appraised value, not the marine surveyor's estimate. If the charity sells a worn 35-year-old fiberglass sloop at auction for $350, the donor's deduction is $350. The fair market value appraisal of $12,000 is irrelevant to the IRS. The deduction follows the sale price, and that price belongs to the charity's auction results, not the broker's comparable listings. The deeper complication is that most nonprofits decline the donation before any of this arithmetic becomes relevant. Veteran Yacht Sales stated in a January 2026 advisory document that nonprofits turn away more boat donations than they accept because storage, transport, repair, and disposal costs routinely exceed the vessel's resale value. For a $10,000 fiberglass hull requiring $5,000 in transport and another $5,000 in disposal, the charity receives nothing of value and accepts a significant operational burden. It will decline. An owner who has attempted a documented donation and been declined now has a paper trail showing the vessel exists, its condition is known to at least one third party, and a transfer of title has failed. That paper trail is accessible to state vessel enforcement agencies, cross-referencing vessel identification numbers against ownership records. The verdict is direct. The charity is not an exit, it is a record. The fix: before initiating any donation paperwork, call the charity directly and ask what their average auction result is for vessels in the same hull, type or short age and condition as yours. If they cannot confirm a figure above transport and disposal costs, the donation will produce no usable deduction and it will produce documentation. Trap number 3, the landfill. For the majority of fiberglass sailboats in the United States, the landfill is the only viable legal disposal route. Fiberglass does not biodegrade, and it cannot be recycled into anything with market value at a cost that makes economic sense. The Rhode Island Marine Trades Association ran the only operational fiberglass recycling pilot in the United States. That program was funded by a NOAA grant of $105,000, and its shredded hull material then fed that material into cement kilns as fuel. Brian Dursey, the executive director of RIMTA, explained the economics in 2023 without softening them. The program paid the cement kilns to accept the material, paid contractors to shred the fiberglass, paid for transport, and paid for dismantling. The grant absorbed the losses. When the grant ran out, the program stopped. It is currently paused. The landfill rate for fiberglass hull material runs $95 to $100 per ton, or approximately $5 per linear foot of vessel. Road transport to the nearest licensed facility adds roughly $5 per mile. A 40-foot fiberglass sailboat generates between 10 and 15 tons of material at the landfill gate. The Maryland DNR documents the all-in cost at $3,000 to $15,000, depending on hull size. California marina operators put the complete figure at $20,000 to $40,000 when legal processing, contractor costs, and disposal are combined. Every landfill disposal generates a manifest. That manifest carries the vessel's hull identification number. The record is permanent and available to state enforcement databases. The math is not subtle. The fix is one calculation run before the vessel goes to market. Obtain a binding quote from a licensed marine salvage contractor. If the disposal cost exceeds the realistic net sale price after broker commission, that gap is the actual financial exposure. It belongs in the negotiation, not as a surprise after a failed listing. Trap number 2, the hull identification number. Every recreational vessel built in the United States after November 1972 carries a 12-character alphanumeric code molded permanently into the stern called the hull identification number, standardized under 33 CFR Part 181. That number connects the physical hull to a state vessel registration record. The registration record links the hull to the last owner who completed a title transfer with the state. When a vessel is declared derelict or creates a navigational hazard on public waters, state enforcement agencies query the HIN against their registration database to identify the legally responsible party. The party they identify is not necessarily the current possessor of the vessel. It is the last registered owner in the state's database at the time of enforcement action. Investigate. West and Cascade PBS reported in July 2025 that the Washington Department of Natural Resources said vessel owners frequently leave the state or become untraceable after abandonment. When they can be located, the Washington Department of Natural Resources pursues liens against their personal assets for the full cost of survey, removal, and disposal. Washington allocated $17.1 million for its derelict vessel removal program in the current 2-year budget cycle. A single large abandoned vessel in Tacoma's Commencement Bay, the Pacific producer, required nearly 2 years and approximately $5 million to remediate and destroy. Moorage costs. While the state waited for disposal funding, totaled $300,000. A private sailboat generates a smaller bill by scale. The legal mechanism that activates it is identical. A handshake sale. A private transfer documented only by a signed bill of sale with no state title registration update. A boat left at a marina under the new buyer's name that never appeared in the DM-VAV system. In each of those scenarios, the previous owner remains the legally responsible party in the enforcement record. The hull identification number does not expire. The database does not close. The fix requires one step before physical possession transfers. Confirm the state title registration is updated and that the new owner appears in the vessel database. A bill of sale is a private contract. The state registration record is the document the enforcement system reads. Those are 2 separate documents, and only one of them protects the seller. Trap number 1. State impoundment. The moment the state removes the vessel and sends the invoice to the name on the registration. In May 2025, Florida's Senate Bill 164 came into force. Under Senate Bill 164, leaving a derelict vessel on state waters is a first-degree misdemeanor for a first offense. A second offense is a third-degree felony. A third offense escalates to a second-degree felony. The bill attaches direct financial liability, making the vessel owner responsible for all costs arising from removal, storage, and disposal. Failure to repay those costs causes the owner to lose motor vehicle and vessel registration privileges in the state of Florida until the debt is cleared. In the same month, South Carolina Governor Henry McMaster signed Senate Bill 367 into law. Under Senate Bill 367, abandoning a vessel on the state's waters is a criminal misdemeanor with a fine of up to $10,000 and imprisonment of up to 60 days. Full removal and disposal costs are the owner's liability. Both statutes identify the responsible party the same way as the last registered owner shown on the state's vessel title record. The Florida FWC database makes the enforcement load visible. The state removed derelict vessels at a cost of nearly $2 million in 2020. By 2024, that figure had reached nearly $13 million, a cost escalation that forced the legislative response. Monroe County, Florida, removes approximately 75 derelict vessels from the Florida Keys each year at a combined cost exceeding $800,000. The FWC official abandoned vessel page carries language that enforcement agencies do not usually put in public documentation. It says, "Removal of derelict vessels is an additional burden for taxpayers, and vessel owners should realize there is an end of life for their vessel." The state already has the registration record. It has the HIN. It has the address on the title. The impoundment notice travels to that address. The fix exists, but only before the hull enters the enforcement database. Florida's Vessel Turn-In Program, VTIP, removes qualifying at-risk vessels at no cost to the owner, provided the hull is still floating and meets the program's eligibility criteria. Once the vessel sinks or is formally declared derelict, the free disposal window closes. The bill that replaces it goes to the name that was on the registration. Across all 5 traps, one pattern holds across every entry. None of them appeared the day the vessel was purchased. Each one was embedded in a federal lien statute, a state registration database, an IRS publication, or a corporate marina contract that existed long before the market stopped producing buyers. The maritime lien attaches at the first dock line. The HIN is stamped into the transom on the day the boat is built. The charity's Form 1098-C reflects what worn fiberglass is actually worth to a non-profit at auction. The Landfill manifest records the hull number permanently. The state enforcement database was running before the listing went up. The market did not create these 5 traps. It made them visible by stopping. For every sailor watching slip fees compound on a boat that is not moving, the 3 actions that matter are specific. Obtain a lien clearance letter from every marina in the vessel's history. Confirm the state title database reflects any transfer before physical possession changes hands. Request a written disposal quote from a licensed marine salvage contractor before the asking price is set. These are not precautions. They are the difference between a transaction and an enforcement record. Have you been served a marina lien or a state removal invoice that nobody mentioned at the time of purchase? Drop the details below.